More than 30 fans injured in that horrific NASCAR crash are now exploring their legal options. An attorney representing the group says he is hoping for a settlement based on the fact that the safety fence around the track failed to protect the victims. But experts say, wait a minute, the plaintiffs face some pretty serious hurdles. Let's talk about it with our legal panel. Keisha Hebben joins us, defense attorney, former prosecutor. Robert Schalk, defense attorney and a former prosecutor. Good to see you both. Robert, let me start with you. Look, you know this. When you hold an event and you invite people to it and you sell tickets and you're making money off of it, the law imposes an affirmative duty to protect those patrons for any foreseeable catastrophes or events. Now, the question here is, was this foreseeable?
Absolutely, Greg. I would go back a number of years now. This has been happening, I think, since about 1999. I think was the first incident that this occurred in.
Sure.
And it's happened in Talladega, it's happened at Charlotte, it's happened at NASCAR events, Indy events, where tires are going over the fences, now through a fence. They have you have the writing on the back of the ticket. We're not responsible for any debris that comes in.
And we'll get to that in a minute. But there's a duty to protect.
100%.
Well, Keisha, look, here's the thing. There was a safety fence,
right?
Sure, but people still got injured. Isn't that proof the fence wasn't safe enough? It wasn't big enough. It wasn't strong enough.
I don't agree, because just because an accident happens doesn't mean that the party breaches its duty to these fans or spectators. The fence was there. The whole car didn't go through, so the fence did what it was supposed to do. I don't think it's necessarily foreseeable.
Okay, so maybe their lives were saved, but they were still injured.
Right, but there could be some contributory negligence, because
contributory negligence when you're
events,
sitting in your seat.
But at these types of events, accidents like this can occur, and I believe that the defendants in this case did have the fence there.
So you're invoking the old doctrine, assumption of the risk, right?
Absolutely. And it's on the back of the ticket.
Right. You know, when I was in law school, it was a long time ago, the law professors used to laugh at assumption of the risk because it's archaic, it's antiquated. It doesn't really apply these days.
Those tickets, it's printed on every ticket. No one reads it. We all know it's there. But at the end of the day, when they fail, when the fence is supposed to stop cars, tires, debris from entering the stands, and that's exactly what happens. You know, Daytona Speedway, NASCAR, they're going to want to absolutely settle this thing before a lawsuit
hits. Here's the ticket waiver. Let's put it up on the screen because it's very interesting. It's standard form. It's boilerplate stuff. The holder of this ticket expressly agrees that all employees, agents, officers, directors of Daytona International Speedway and hereby release from any and all claims arising from the event, including claims of negligence. All right. Here's the problem with that. Isn't that what we referred to in law school as a contract of adhesion? You have no ability to negotiate that. You're strong-armed into that contract if it really is a contract. Put up on the screen contract of adhesion. I dug out the old Horn book on here it is. I mean, it's a standard form, favors one party, the other party has no ability to negotiate. It's unbalanced, unfair, unconscionable, unenforceable.
But you know what, Greg? Anyone who attends these types of events, just like at baseball games or hockey games, they know that these are things that could happen. Now, nothing's 100 accident proof. So we can say, all right, well, the fence wasn't high enough, but I think that they did their due diligence, or they fulfilled their duty to these fans by having the fence there in the first place.
You know, I like her baseball analogy here. You could get hit by a ball, and nothing could protect a fan up in the upper decks.
But a ball is foreseeable. An engine, a tire going through a fence that's there to protect you. There is netting behind the plate. There is plexiglass around some baseball stadiums.
People still get hit.
People still get hit, but you also do hear about lawsuits. There was a hockey lawsuit where a girl in Columbus was killed. There was no netting, and the ticket had the waiver, and the NHL paid $1.2 million to that family. Yes, the waiver is there in the back of the tickets, but every time this happens, there's always a payment.
If it gets in front of a jury, here's what happens. The plaintiff puts an expert on the witness stand, duly qualified. He's going to say, you know what? They could have built a better fence that would have protected these people from injury. And that's the case.
But then Daytona will have an expert to say, you know, the fence was there, they did what they were supposed to do, it wasn't necessarily Daytona's fault. And I think comparative negligence will come into play to try to limit any damages or
Daytona's
liability.
fear is going to be if subpoenas start getting filed on them for emails, for letters, for board meetings, where someone maybe said in 2009 or 2010, we got to improve our fences, and it didn't happen.
Can we all agree they're going to settle this thing? It will never get in front of a jury. You don't want this in front of a jury.
Right.
No, it's bad PR.
Okay. Robert Schalk, Keisha Heaven, good to see you both.
Good to see you.
Thanks very much. Heather?
Well, coming